Thank you. Please be seated. All right, good afternoon. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Mr. Daybell is here present, represented by his attorney, Mr. Pryor. The state's here present, not currently seated at the prosecutor's table. Seated there is attorney Terry S. Ratliff, along with another attorney, Mr. Bartlett, who represents Mr. Ratliff. The court is taking up today an order to show cause hearing, and I'm going to briefly discuss the procedural history that brings us to this at this time. I'll note that this was a motion that was filed by Mr. Ratliff, who is a bar licensed attorney through the state of Idaho, and filed a pleading purporting to be the attorney for the defendant in this case. And the pleading was filed on March 29th at 11:42 p.m., so shortly before midnight on a Friday. And I do want to discuss briefly the timing of the filing. The court was conducting jury questionnaires and preparing for jury voir dire in this case, which of course is a capital murder case, an incredibly serious case where the court counsel has spent a tremendous amount of time preparing for and getting ready for trial where we are now. The court was not made aware of the filing because it was not entered in the case until Sunday morning on March 29th. That would have been on March 31st. That was Easter Sunday before we were going to start with our voir dire the following Monday. On Easter Sunday, my staff attorney, who had an opportunity finally to travel home and spend Easter with her family after a very long week, was interrupted out of her church services and contacted the court that we had an emergency happening in our case that was going. And the emergency was, we had a motion to continue the trial. And I wasn't sure who was asking to have the trial continued, why the trial would be continued, but this created a tremendous amount of quick response required by the court, by staff, by clerks, by the prosecutors, by the defense, all occurring again on one of the few days we had a break as we were grinding through jury selection on Easter Sunday. The pleading the court received is entitled Motion to Intervene and to Continue the Trial in These Proceedings, filed by Mr. Ratliff on his official office pleading letterhead, signed by Mr. Ratliff as the attorney for the defendant, both on the signature line and on the caption. I'll note the pleading incorrectly spells the word motion. It incorrectly spells the word continue. It incorrectly spells the word proceedings in its caption. And when I reviewed this, I'm going to tell you, Mr. Ratliff, I was angry then, and I think I'm angrier now about what you did. However, in light of allowing you some due process, I looked through a correct way to handle this, and I considered Rule 11. I'll note you've retained an attorney, Mr. Bartlett, and I have reviewed a lengthy response brief along with declarations submitted on your behalf. And procedurally, where we are, first of all, the order to show cause for me is for you to explain, Mr. Ratliff, to personally explain to me how your pleading complies with Rule 11 of the Rules of Civil Procedure. Typically, when someone shows up with an attorney, their attorney gets to argue for them. However, under certain circumstances, I don't know that the right to counsel attaches, and in particular, under a Rule 11 request, I don't believe it does. I'll note the Rule 11 is a rule of civil procedure, which typically would not apply in a criminal filing. However, there are rules under the criminal rules that states we do follow civil rules when there's no corresponding rule. And in particular, criminal rules 47 and 49 indicate that filings of motions in criminal cases are to be filed in the same way and manner, and using the word manner, in which pleadings have to be filed in civil cases. Rule 11 governs licensed attorneys and the representations they make. There's been some indication of your counsel that perhaps Rule 11 doesn't apply. I believe Rule 11 does apply. I don't believe lawyers can file whatever they want in a criminal case without being subject to the representations under Rule 11, where they certify certain things and making those filings as officers of the court. To argue otherwise would say any lawyer could file anything they want in a criminal case and not be subject to any kind of sanction under Rule 11. And I believe Rule 11 permits exactly that, for me to consider it. Rule 11 under Part C3 allows the court to conduct an inquiry on its own initiative, and the court has done this, not at the request of the parties, but at my own request, because I do have questions for Mr. Ratliff. And I'll note procedurally, while I appreciate the time and research Mr. Bartlett has put into the case, we don't have a party in this case appearing before me. Mr. Ratliff, you are not the defendant. You are not the state. You are not a prosecutor. You are not the defense attorney. You are an attorney with a license that filed something asking me to stop this trial when I don't think you had any legal standing to do that. And I'm going to give you personally an opportunity to make any explanation you want as to some of my questions. I am not going to turn this into an adjunct litigation under the auspices of this capital murder case, because quite frankly, you don't represent the defendant here. You don't represent the state. You're not a party. And I'm not going to let this devolve into a whole separate procedural mess in this case and create a record of some side issue that has nothing to do with the charges the state is currently putting evidence on for. So now that I've had my say about how we got here and why we are here, Mr. Ratliff, I have questions for you under Rule 11. And if you'd like to answer those questions personally, I will ask you some questions. If you don't want to answer those questions under the advice of counsel, I'll understand that as well. And I don't know that I even need any input from the parties. So, Mr. Ratliff, are you going to answer the court's questions as it relates to Rule 11?
Get him a mic, please.
Okay. Otherwise, I think really good earlier it's in the process. I think the process will be required. The rules regarding consent. I'm not in contempt. I'm not in contempt, Mr. Bartlett. Well, what the basis was, what he had school, was he showing contact with was he showing cause whether or not he complied with Rule 11? Was he showing we didn't know. We only learned late on the 16th that I was told about Rule 11. Oh, was that inconvenient for you? Was that? I'm asking you a direct question. Was that inconvenient for you? It was only that I didn't have the amount of notes necessary. It's not Mr. Bartlett, hold on. I indicated I wasn't going to have you argue this motion. I allowed you to start making it, and you are doing precisely that. I've thought this through. I'm in Rule 11 here. I'm in a rule that governs lawyers and their pleadings. When lawyers sign off on pleadings, lawyers are responsible for their pleadings. Lawyers, unless they're facing a sanction of jail under contempt, do not necessarily have the opportunity to have counsel represent them on a Rule 11. If you file a frivolous civil complaint and a judge says, I'm going to award fees because it was frivolous, you don't get to have another lawyer from another firm jump in between you and the judge and the complaint you filed, because you have the responsibility as a licensed attorney to put your name on pleadings and stand behind your signature under those rules, under Rule 11 and what you certify, and you answer those. In my opinion, and I'm the judge here, this is how you address Rule 11. So with all due respect, Mr. Bartlett, I appreciate you attempting to and wanting to represent your client. Again, you can do that. You've talked to him before. You can talk to him after. But the questions I have on Rule 11 relate directly to a pleading that Mr. Ratliff filed as licensed attorney in this case. And I have a right to ask him about his pleading that he filed. And so if you want to take a moment to consult with him, you can do that, but I'm not going to have you argue the merits of this. That will be up to you or Mr. Ratliff.
Ask that I have an opportunity to speak with him. So thank you so much for that.
Okay, I'll take the time you need. I don't want to spend much more time this afternoon. We're in the middle of this trial. We've had evidence today. We're going to have evidence tomorrow. Make it quick and then let me know what your client wants to do.
Yes, sure.
Sorry,
All
I
right,
thought it was
Mr.
over.
Ratliff, I have some questions about your pleading. Are you willing to answer those?
Sure am.
All right. The pleading I'm looking at, it's not been entered in the case yet, and the pleading give me just a second. All right, you did in fact file this electronically in CR. Well, that's wrong to the case number, but this is case CR 22-21-16-23, the state of Idaho versus Chad Guy Daybell. Is that correct?
That's correct.
All right, I'll note the case number is wrong as well. You've got it CR 12-21. The first part I want to know under Rule 11, which requires you to make representations to the court, you hold yourself out as, entitle yourself attorney for the defendant. Why do you say that?
Judge, as you know, this is a template form, and I simply forgot to take that off of there. That was Scrivener's error on my behalf.
Okay, Scrivener's error. On the,
If you notice in the body of the motion, Judge, I say without permission of the defendant or his trial counsel.
all right, let's look at your signature on page 3. You signed Terry S. Ratliff of the firm, attorney for the defendant on page 3, don't you?
Again, because it was in my template.
All right, on page 2, again, a signature, Terry S. Ratliff of the firm, attorney for the defendant, correct?
I don't have a page 3, Judge. I just have a page 1 or 2.
Bottom of the certificate of service is one signature, another at the bottom of the contents of the pleading.
If it's there, Judge, it's there because it's a template form and I didn't strike it.
Okay, so 3 times you called yourself the attorney for the defendant. So who are you the attorney for?
Hey,
So Terry S. Ratliff, attorney for Terry S. Ratliff in this case.
I should have signed citizen.
Citizen?
Yes.
Why are you
Avoid-
referencing your bar number if you're just citizen?
Again, it's the form, Judge. It's a reference to the form. I'm not Mr. Daybell's attorney, never was.
You put this on a pleading. If you look at the top left, you've got your name, your Idaho State bar number, your Ratliff Law offices, and attorney for defendant. You're telling me you mistakenly just wanted to file something as a citizen and not as a lawyer?
I was looking for immediate relief because of the concerns I had about the case, Your Honor.
And why were you doing that on a Friday night at almost midnight? What,
Because-
you've known about this case for a long time, according to your own content here, right?
That's correct.
So why are you doing it then?
Because I thought I needed to do something to slow it down.
Trial scheduled for how many years? And you wanted to slow it down the day before trial started?
I'd also gotten calls from Mr. Pryor, Judge, for help.
That might be fine, but did he ever retain you on the case or did you ever enter an appearance for the defendant?
I did not.
All right, and you do state in here you're filing this pleading without the permission of the defendant or his counsel, correct?
That's correct.
You also state in here and call yourself an intervener. What basis do you have to intervene?
Based on my,
On the brief.
it's set out in our brief, Judge, as to the basis for why I wanted to intervene.
Hmm.
In the motion, I quote you the relief I wanted. I give you the grounds on page 1 as to why I wanted that relief and why I thought it was necessary.
Okay, and you're gonna intervene now, not as Terry Ratliff lawyer, Terry Ratliff citizen at large?
I think it's semantics, Your Honor.
Oh, boy, let me stop you there. It's absolutely not. A bar licensed attorney filing something with their bar number to the court is completely different than a citizen. That is not semantics. This is
Okay.
what brings you within the auspices of Rule 11.
I understand. I said perhaps I should have signed it as a citizen, but I didn't.
All right. In your intent to intervene, whether it's as a citizen or an attorney, let me read you a couple of case quotes. Quote, "The Idaho Rules of Criminal Procedure do not provide a process for intervention. The inability of non-parties to intervene in a criminal case recognizes that the considerations underlying intervention in civil cases are not applicable to criminal proceedings." That's People versus Ham, and that's State versus Johnson, 167 Idaho 454. And we've also got another Idaho case citing, quote, "Petitioners are correct that Idaho's rules of criminal procedure do not provide a specific mechanism for third parties to intervene in a criminal case." So again, I think there's settled case law that prohibits intervention in a criminal case. And I'd like to know what authority you have that says you have a right to intervene either as an attorney or a citizen in this case.
As outlined in our brief, Judge, sorry about that. As outlined in our brief, we have given the court several cases where the Idaho appellate courts have allowed people to intervene in cases in a criminal matter, even though they're not parties. That's my basis.
So you intervene and then we've got two parties here. We've got the state, we've got Chad Daybell. And you're going to float around and be what if you intervene in this case? What are you going to be?
I'm not going to be floating around this case, Judge, because you haven't granted my motion.
Well, assuming you got to intervene, you assumed in your motion you did intervene because you called yourself the intervener once you got going in your motion. What were you going to be at that point?
I was hoping to have a hearing in front of you before the trial started.
Okay. And you said you were going to be the lawyer for the defendant or already were the lawyer for the defendant. Is that?
Not. I explained to you just a few minutes ago that that was a mistake.
Explain to me all of the misspellings and typographical errors in your late night filing.
I was nervous and it was late at night. I didn't take this lightly.
You didn't take it lightly, but you used the wrong form. You misrepresented if you were an attorney or a citizen and you signed 3 times as attorney for defendant. And that's your explanation?
Yes.
All right. Mr. Ratliff, I find based on your responses, you have violated Idaho's Rule 11 under the Rules of Civil Procedure, which I find are incorporated through Idaho Criminal Rule 47 and 49. The court would note that in the rules under C1, it's mandatory it says the court must impose an appropriate sanction on an attorney, law firm, or party that violated the rule. And similar to what would happen in a civil case with a frivolous type filing, which this was, this cost time, this cost effort, this cost real loss for the attorneys, for the court. I'm going to instruct counsel for both the state and the defense if they could itemize the time they have spent both in today's hearing, in preparing for the hearing, as well as in dealing with this pleading from the time it was filed on Friday night, the 29th, whatever time you've put into that. I'm going to direct Mr. Ratliff that you pay reasonable attorney fees incurred for the time Mr. Pryor spent at his typical hourly rate for the state's attorneys and whatever rate they are entitled to charge as public prosecutors. And the court will likewise itemize some billing time incurred in this. And the sanction the court's going to order is the payment of those attorney fees. The court will provide time for counsel to submit those. I'll review those for reasonableness before I make an order, and pursuant to the rule which requires a written order under Rule C6 of Rule 11, the court will describe in that order the conduct and the basis for the sanction, and you're going to pay for those fees. Do you understand that, Mr. Ratliff?
That's fine, Judge.
Very well. That'll
Your Honor, if I may, I'm going to request findings of fact and conclusions of law. As this court is aware, we submitted briefing that addressed many of the issues you addressed to Mr. Ratliff in great detail, giving multiple basis for his right to intervene. The judge, you have not addressed those arguments, and so I'm going to ask for findings of fact and conclusions of law.
All right. Well, Mr. Bartlett, you can ask. I'm not inclined to do that because, again, I've got a lawyer in front of me that submitted a pleading, and the lawyer is responsible for the pleading. I'm not necessarily allowing any further input on behalf of counsel for the lawyer that filed the pleading. I don't think it's proper because I'm not imposing any kind of jail time or sanction similar to Rule 75 of the civil rules, which would implicate on a contempt proceeding the right to counsel. So I'm going to stand by my ruling that I made and ask the attorneys to submit those. That concludes the matter for this afternoon.
Judge, if I may. Judge, I am
not. I'm done. I'm done with this issue, and I'm done wasting time on this issue in the middle of a capital case. We're done. We're in recess, period.
Period. End of story. In other words, stop. Oh my goodness. Oh, wow. That was good. That was good. I was wondering, I remember when that happened. I remember when that came out, and like somebody filed that right as jury selection was starting. Are you kidding me? Whew, good one. Okay, now we can all take a breath. Oh, no, I was so wrapped up in what was going on that I didn't hear him say, I'll be right back, or whatever it was he said. Oh, whew, that was good, good, good. So that he made him he's got to pay his fees, pay all the stuff. And I love at the end of it, period. In other words, shh. Okie dokie. So, well, now our day is over. Oh my goodness. I need a breath. I was holding my breath about half of that. Oh, that was good, good, good. Good stuff. All right, everybody. Thank you for being here. I've got to cut the rest of Melanie's stuff, and I've got to get this as a clip because this is worth getting a clip of it. And I thank you guys for being here. I thank you for supporting me and this tiny little channel I got going on over here. And I will see you bright and early in the morning. I'm sorry, I had to get. Oh my goodness, guys. Oh, I can't. I gotta say goodbye. I gotta say bye. I can't breathe. All right. Take care. I will see you guys tomorrow.